All right, well, we're back here. It's Justice for All. I'm George Yates. We got another hour to go on this lovely sunny day. God, it was some terrible weather this week, I swear. Rainy and miserable that whole week. It seemed like it was the worst kind of weather we can possibly have, and now it kind of looks like spring. Days are getting longer, so, it won't be too much longer before I'll be pulling out the paddleboard. I was on the phone this morning to a realtor in Hatteras Island, and she said that people are out there on their kayaks out on the Sound this morning. Lovely day down on the Outer Banks. So, spring is in the air. It's still January, but the days are now getting longer, and we'll get here to Martin Luther King Day on Monday, and then we'll be 1 month out from the shortest day of the year, which, as we all know, falls on December 21st. So we're 1 month out, and days are getting longer. So that's great. And I read in the paper this morning that 2014 was the hottest year on record since we've been keeping records since 1880. So those of you out there who don't believe in global warming or don't think that it's a hoax, I think it's definitely a reality. It's a little scary, especially for those of us that live around here, because we're such a low-lying area. And I know that as this global warming thing goes on and as the ice caps begin to melt and sea levels rise, we're kind of at risk in this area. I don't think we can avoid it anymore. Yet, I drove here today in a car that burns gasoline, so I don't need to be too hypocritical about it. I'm putting carbon into the air myself. My carbon footprint's probably not the greatest. So those of us that want to complain about global warming probably should do something about it. I've seen some articles lately on electric cars. I don't know how we're going to go as a society to resolve this global warming thing and the fact that we're putting too much carbon in the air. But it's something that we all need to think about for our children, if not for us so much for our children, because 20, 30, and the young people here, like my engineer here, D, he's only about 20 years old, so D might watch the sea levels rise enough so he's got to move from our area to someplace a little higher ground. We'll see. But that was a scary situation. Read that this morning. And I read in yesterday's paper that the oceans are really at risk. And we all know that the coral reefs, 40% of the coral reefs worldwide are gone. And so wouldn't that be something if we reach the point, and as they said, I read the article, and as it said, if you got a fish tank at home and you decide to crank up the temperature on the fish tank and then dump a bunch of acid in the tank, your fish might not like it a whole lot, and some of them are going to die. So we've got some real issues as a society going forward. Today, I'm a criminal defense lawyer in Virginia Beach. I've been doing it now for 25 years. I was a prosecutor in Virginia Beach from 1985 to 1989. And today I thought what I would do this next hour is throw the phones open if anybody wants to call at 454-1650. I wanted to talk about, some of the things that I do. And over the course of the next 6 or 7 weeks, what we've been doing is interviewing guests the first hour, and then the second hour I've been just talking about topics of interest. And I'm talking about DUI law a little bit in the next few minutes here today. And those of you out there who want to know about DUI law, or if you've ever been charged with a DUI or know something about it, one of the things that bothers me about DUI law and the DUI situation we have is that in the last 40 years or 50 years, we've had this kind of gradual change to become more and more and more hard on DUIs and DUI drivers. And the thing that bothers me as an attorney who's watched this thing go forward, when I was first practicing law back in when I first got my license in 1982, that was not too long after the breathalyzer result to find you guilty of driving while intoxicated was 0.15. And over the years, that limit has dropped from 0.15 to 0.10 to 0.08. And the point that I'm wanting to make today is that the person who's driving along at a 0.08 and a 0.09, a 0.10 is not really under the influence so much that their driving is impaired. I know the National Highway Transportation Safety Administration says that people are impaired, but I can just say from my experience in defending thousands of DUIs in the last 25 years, that people that are in '08 and '09 are not that impaired in driving. And what's happened in our system today is a person that has a martini or two and gets in their car and they're driving home, and they might be a mile or two from home, and they get pulled over. They don't get any kind of a break anymore. And they are driving fine. They might be pulled over because their license tag is out. An officer might even say they followed them for a quarter of a mile or half a mile, and their driving behavior is perfect. But what ends up happening is this person now gets out of the car, and they're being asked to go through some field sobriety tests. And I'm discovering also that these field sobriety tests that people are being required to pass along the road after they've been stopped for a DUI, these tests are almost impossible to pass, especially if you're a little older. Now, for the same reason that nobody is quarterbacking the NFL beyond 38 or 39, I guess Peyton and Tom Brady are still in the game. You don't see athletes past 40, and yet somebody that's 40 or 45 is being asked to get out of his car, or she being asked to get out of her car and do these field sobriety tests along the side of the road. Now, at some point, they might also be required to give a breathalyzer, and they do a breathalyzer. Now, if somebody blows a .15, that's drunk. 0.15, 16, you're starting to get into those areas where somebody really should not be on the road. My issue is the fact that they lowered that 0.15 so that somebody that might have a 0.10 or 0.09 or 0.08 is also caught up in that and is declared a driving under the influence, when in fact they really weren't impaired. Their driving was fine. They get pulled over because they had a headlight out. They got pulled over because they had a taillight out. They got pulled over because they hit a roadblock. And so someone, have you been drinking? Well, yes, I have. And that person doesn't even know that they're under the influence when they leave the home where they've been drinking, or the bar where they were. Their automobiles do not have mandatory sensors in them. That person is driving. I'm perfectly fine. They might have been they've left a pool hall, and they might have just been run the table. And it used to be when I first started practicing law, and the legal limit was 0.10. And even 0.10. So if someone had an '09 back in 1984, 1985, 0.09, you wouldn't be found guilty of DUI. Somewhere along the way, they decided, oh, no. If you got an '08 now, you're impaired. But the fact is, many people are not impaired at '08. But they're being asked to do these field sobriety tests, which are almost impossible to pass, no matter how coordinated you are. And the way these officers administer them, and I know the officers are doing their job, but these days, when people try to go do that walk and turn test, the one-leg stand test, and the horizontal gaze and nystagmus test, and they're being told that they've failed that test, then they go do the breathalyzer, and they do an '08 or an '09. And all this pressure that we've had from Mothers Against Drunk Drivers to get drunken drivers off the road, and I am all in favor of getting drunken drivers off the road if they are drunk and they are going to harm somebody. But I think what we've done is we've brought all these other people in that really were not impaired. I really disagree with these arbitrary 0.08, 0.09, 0.10. And I wish we had a little more flexibility. But what's happened is there's so much political pressure now in Richmond. If you're a judge in the General District Court or the Circuit Court, they're basically, all the judges now are being told, you let somebody go that's got an '08 or an '09 or a 10, even a 11, you let them go, we're not going to be reappointed. You're not going to be reappointed as a judge. I mean, that's the political pressure that's on. And Mothers Against Drunk Drivers have their heart's in the right place. They want to get drunk drivers off the road that might kill somebody. But the statistics show that very few of the people that are being caught for, let's say, a 0.0. I mean, what are the chances of someone with an '08 or '09, 10 actually driving his car in such a way that he's going to harm somebody? Very low. I can tell you, I'm sitting in my office. Here comes a DUI client. I don't even have to look at the paperwork. I'll ask him, I'll say, why were you pulled over? He'll say, oh, my license tag light was out. Okay. You probably blew an '08 or an '09, right? Maybe a 10. Why? Because officer didn't stop me because I was weaving. Officer didn't stop me because I had an accident. Officer didn't stop that person because they were doing anything unusual at driving. The officer, though, as Adam Plantigo, our officer who was on a couple of weeks back, police officers can pull people over for any reason, just about anymore. They'll pull somebody over for running through a stop sign. They'll pull somebody, because everybody, even my dear departed mother, probably rolled through the stop signs. So somebody's out there, let's say on Shore Drive in Virginia Beach, they leave Hot Duna, they had a martini, and then maybe a beer, and they just got right to '08, and they get in their car, and they're driving down Shore Drive, let's say towards the Lesnar Bridge, where they've got a condo. They're driving about 2 miles, and their license tag is out. There's 2 lights on the license tag, I guess, and they have to have both of them operating. Officer pulls them over. Officer might even been sitting in the parking lot. Watch them leave. And they're going to end up with a DUI because they blow in '08 and they fail the field sobriety test. There have been some, and it's just something that it's disturbing to me that now when we're having prosecutors on the case and nobody ever gets a break anymore, and that person is being branded as really, that person probably has never been charged with a crime in their entire life. And now they have this DUI conviction, and really they weren't even driving. They really weren't that impaired. I'm saying that impaired. They weren't impaired. But we've set this arbitrary limit of .08 where we said that's impaired. It's the same thing as saying you put somebody out there. What if you've got a 55-year-old, let's say, overweight man, and now you've got a 22-year-old highly athletic man, and you're asking them both with the same level of alcohol intoxication to take the field sobriety test. Well, the fact is the 22-year-old athletic man's going to do better on the test than the 55-year-old man. In fact, studies have shown that once you go over 40 years old, and even sometimes younger than that, your ability, your balance, and your ability to pass these tests is so limited that I don't think anybody can pass. And people will tell me this all the time. I can't pass that test even if I'm sober in the middle of the day, and they are right. And yet, you know what? Police officer will come into court, and that person will be convicted based upon this person's inability to perform these field sobriety tests in the middle of the night when they're already tired. They might have had a drink or two. They're not doing anything wrong with their vehicle other than maybe hitting a roadblock. And they're going to end up with a very serious criminal conviction for DUI. So these are the things that are brought to bear as I'm defending criminal cases all the time. I'm defending these DUIs all the time. And I work so hard at trying to make sure we got some way to try to get these field sobriety tests challenged, and also to challenge the accuracy of these breathalyzer machines, which convict people based upon what a machine says as opposed to what the actual driving behavior was. So that brings us to this question, which people always have about DUIs, and that is, gee, should I refuse the breath test? And that's always the question, isn't it? When I'm pulled over, if I make the mistake, and it happens to almost everybody, that we live in an area where there's very little ability to get a ride home from public transportation. You try to call a cab, you're not going to get a cab for hours. And people will just say, I just think I'm going to go ahead. I'm just going to try to go home here, and I'll get in my car and I'll drive. And they might even sit in the bar for, let's say, another hour and drink water, get a cup of coffee, and relax a little bit and say, okay, I think I'm all right to drive. And they feel that they're okay to drive. And then they're pulled over for some minor infraction that has nothing to do with bad driving. And their first question is, they're pulled over by a police officer, and they say, what do I do? Well, most people, when they see a police officer, they're cooperative. So they'll say, well, I think officer will say, do you mind getting out of the car and taking some field sobriety tests? If you're going to refuse the field sobriety test, which you have the right to refuse the field sobriety test, you also have the right to refuse the breathalyzer test, except the officer doesn't inform you that you have the right to refuse the field test, even though you have the right to refuse it. Now, the breath test, they'll always say, you've got the right to refuse this test, but if you refuse this test, you're going to lose your driver's license for a year, or you may lose your driver's license for a year. And what ends up happening so often is that people will take the field sobriety test, but then refuse the breath test. And now what's happened is they've given the officer and the prosecutor and the court evidence which can be used against them to convict them of the DUI, even though they've never taken the breath test. And these fields, and this is where having a good lawyer comes in. Because if there's no breath test, the only way you're going to be able to prove the DUI case is to show that you were driving under the influence. These field sobriety tests, I went to a seminar one time on DUI, and they call them, they're field calisthenics tests. You're being asked to walk a tightrope. The walk and turn test, there's 3 tests that Virginia Beach and Virginia police officers give in a DUI and DUIs. One is the horizontal gaze nystagmus test. That's where they take the pen and you hold it and they make your eyes go back and forth and track the pen. Nystagmus is what they call this jerking of the eye when the eye is going to the 45-degree angle to follow the pen that's being put up in front of your face. It's supposedly a scientific test to show whether or not you're under the influence or not, or whether your body contains a certain amount of alcohol. The test itself is supposedly scientific. There's many studies that have shown that it's not an accurate predictor of whether or not you're driving under the influence. The second test they usually give you is what they call the walk and turn, and they make you stand heel to toe, one foot in front of the other, while the officer gives you the instructions, and then you're being asked to walk like on a tightrope with your hands at your side, 9 steps up and 9 steps back. And so many people will do that. They'll take the 9 steps up, they'll take the 9 steps back, and then the officers will say, now, when you make your turn, you have to make a series of small steps. Officers are really big about this. You have to make a series of small steps when you make your turn. And most people don't take that series of small steps because they want to do like the old military turn, don't they? They do the 9 steps, then they get right to the end of the 9 steps, and then they do their little about face. Ka-ching. Police officers say, you failed. You didn't make the proper turn. Then they make the 9 steps back. You're supposed to go heel to toe. You can't step off line. But the officer's not even having you walk a line. It's an imaginary line. It's not even a real line often. And then you finish that test. Officers will say, well, you failed that test. And the person will say, well, how did I fail the test? Oh, well, you made an improper turn. Or you missed heel to toe on the 3rd step of the second 9. Now, anybody out there listening to this show, go stand up in your room and go stand there and walk a line, 9 steps, with your hands at your side, 9 steps up, and then make heel to toe all the way up, outstepping off line, out raising your arms for balance. Make that 9 steps all the way up. Make that turn with a series of small steps, not an about face, and do the 9 steps back. You must complete that perfectly, or else you have failed that field sobriety test according to the police officers. Now, the 3rd test is what they call a one-leg stand. Now, one-leg stand, they'll make you count to 30, and the officers will not even count. You're supposed to just hold it in the air. They don't even let you know how long the count is. It's kind of unfair to have you stand there. You get to pick whatever leg you want to put up, but you got to stand there on one leg, and then you've got to put your foot off the ground. You have to put your hands at your side. You cannot sway. And when the officers decide, when they're grading you, it's, do you sway while balancing? Have you had to use your arms for balance? Have you had to raise? Did you hop, or did you put your foot down? There's 4 little boxes. If they can check 2 of those boxes, then you've failed that test. One of them is sways while balancing. The other is hands at your side, or use arms for balance. The 3rd is put foot down, and the 4th is hop. Now, I don't know how in the world, in my 25 years of defending cases, I've never been able to determine how somebody that's standing there on one leg, with one leg in the air, 6 inches or 10 inches off the ground, hands at their side, trying to hold that leg up in the air, is going to hop. I've never heard of anyone that actually has done the hop. That's kind of ridiculous. It is impossible. Go do it. Stand there and put your arms at your side and put one leg in the air and count to 30 and not sway. You can't do it. I'll bet Tom Brady can't do it. You're going to sway. You cannot stand on one leg for 30 seconds. Now imagine if you're somebody that's 40 years old or 45 years old and don't have the greatest balance in the world. Are you not going to sway while balancing, while you're holding your leg up in the air for 30 seconds? Some people don't have very strong legs. 30 seconds to stand on one leg. What if you're overweight? What if you're not particularly athletic? Right. And a lot of times, too, it's late at night. Most DUIs occur at night. You've been up since 6 o'clock that morning, 7 o'clock that morning. You've gone to work that day. You've had a long day. You might have not gotten a whole lot of sleep the night before. You might have not gotten a lot of sleep the whole week. This might be a Friday night. When do these DUIs happen? Friday nights and Saturday nights and so on. It's well known that people that are sleep deprived can exhibit the same kind of mannerisms as somebody who is under the influence. So here you are. You're expected to pass these tests along the side of the road. And then after this officer has advised you that you've failed these tests, they offer you this, what they call the preliminary breath test. Now, the preliminary breath test is a test. It's a little machine. It's a little, you blow, and they offer you that at the scene. It cannot be used against you. That's why they call it the preliminary breath test. Officer will even tell you that it cannot be used against you. Now, I always recommend to people that they probably should take this test. It might give them an idea whether they can pass the one down at the station. I don't think people should take the field sobriety test at all. I don't think that you can pass them even if you're athletic. And so the officer that's making you go through these tests only is using these tests so they can convict you. You're not going to be, if the officer is determined that you're going to take some field sobriety tests, the chances of you going home that night are pretty low. So, I just think that if you're being pulled over, you need to exercise. It's just like anything else. You can't go call an attorney in the middle of the night, call your lawyer, gee, what do I do? But you do have a constitutional right to refuse to take these tests. And it's important that people understand that. Call my law firm, call another law firm. I'm George Yates. You can call my law firm at 491-8800, or you can call another law firm, certainly not during the stop. But ask these kinds of questions if you are someone that ever drinks at all, and you ever want to find yourself out driving, and you want, because it's not against the law to drink and drive. There is no law against drinking and driving. If you got a .06, it's not against the law. 08, it is. And in my opinion, after observing these cases for these last 25 years, 30 years really, people that are in 08 or 09, in my opinion, are not impaired. Your average person is not impaired. There might be someone who is. There might be somebody who's impaired at any level. But I think that the level of dropping it down to 08 was a mistake. I've been opposed to it ever since it happened. We're going to go to a break right now, and we're going to come back and we're going to talk about DUI law in Virginia. I'm George Yates, and this is Justice for All.
If finances are holding you back from enrolling your kids or grandkids in private Christian schools, call the radio station at 488-1010. We have a partnership program with several schools on the peninsula and the south side that allows us to offer a 35% discount off tuition for preschool through the 12th grade. Give us a call today at 488-1010 or visit our website at tuitionsolution.org. Did we mention we added daycares to the site? tuitionsolution.org.
Have you been injured in a car accident or other circumstance? Are you in pain, facing a mountain of hospital bills? Is an insurance company trying to get you to settle without an attorney? Call the law firm of George H. Yates, an experienced personal injury lawyer that can give you the advice you need to make the best decisions. Pick up the phone right now and call 757-491-8800. That's 757-491-8800. Call 757-491-8800 now for a free consultation.
RM Designs T-shirt printing and more is located in Smithfield, but serves all of Hampton Roads. They specialize in vinyl designed shirts, apparel, window stickers, cups, and other specialty gifts. They also have rhinestone and embroidery designed apparel, and they offer Pandora-style beads and hardware to create a one-of-a-kind piece of jewelry. RM Designs T-shirt printing and more caters to businesses, sports teams, churches, groups, and family reunions. They also offer a great fundraising package should you be in need of money for a special project. And they also do home parties if you and your friends would like to get together and make your own creations. RM Designs T-shirt printing and more can be reached at 757-255-9140. That's 757-255-9140. Email them at rmdesigns11@aol.com or find them on Facebook at RM Twisted Designs. You can also place orders directly off their store at storeenvy.com/RM Twisted Designs.
You are out of order. You're out of order. You're out of order. The whole trial is out of order. They're out of order.
Okay, we're back with Justice for All, and I'm doing my my DUI show here today. And as we were talking earlier, when you realize that we've dropped this in the last 20 years, we dropped this 25 years, we dropped the breathalyzer level from a 0.15 to a 0.08. We dropped it in half. And yet, when you talk about if you do blow and you blow a 0.15 or higher, you're going to automatically mandatory go to jail for 5 days. If you're convicted of a DUI and you blow a 0.20 or greater, then you're going to go to jail for at least 10 days. Mandatory time, you got to serve it. A lot of times if you're a first offender, you get to do it on weekends and that sort of thing. So there's any number of reasons why some people might want to refuse that breath test if it's a 0.15 or a point, if they really believe that they're under the influence, then they want to refuse. If they're going to do that, they ought to be refusing everything, refusing the field test as well. So that if they're going to get convicted, what are they going to get convicted on? Now, a lot of times an officer will pull somebody over, and and by saying all of this, by the way, I am not trying to be adverse to law enforcement. I am not trying to encourage drinking and driving. I'm not trying to encourage that everybody should be very, very careful about this sort of thing. I'm not. It's important that we understand what this is all about. I'm just trying to let people know what their rights are and what their constitutional rights are. If you believe that you're impaired, you shouldn't drive. Even if you believe that you're an 08 or an 09, you should not drive because that is the law. I'm advocating, I think that the law is, I don't agree with that law, but that doesn't mean that that's not the law. And so I'm trying to encourage people to comply with that law. But the problem with it is that somebody makes a mistake. They didn't really realize until after they got in the car and they got themselves a little bit on their way home. And all of a sudden, they look up and they're being lit up. They thought, well, you know what? I think I'm okay. I left the bar. I've only got to drive a mile and I'm home. In fact, I've got a client right now that's coming up on a court case soon. He had already made it all the way home to his home street. When he was pulled over, he was one house away from home. Did they let him go home? Nope. They arrested him. He'd made it all the way home. I can't tell you how many clients I've had where they'd made it all the way back home. They're even in their driveway. Police officer pulled them up, lit them up, and charged them for DUI. They didn't hit anybody. They didn't cause any damage. They made it all the way home. And, years ago, somebody would have said, you know what, sir, I'm just go ahead and give you a warning and let you go home. Right. But nowadays, you get you get charged, and then you ultimately will get convicted. But the point I'm making is that when we went from that 0.15, if somebody is charged with a 0.15, they're going to go to jail. Something else is interesting, because I sue drunk drivers from time to time as a personal injury lawyer. If you sue a drunk driver for causing an accident, and this is where we do have that drunk driver is not going to pay punitive damages unless they've got a 0.15 or higher. Most people are not in accidents unless they're at a 0.15 or higher. It's really fascinating for me. When I interview, like I said, when I interview a client, I can already tell you what their breathalyzer is probably before I even look at it, depending upon the circumstance and how they're in my office. If they're coming in there and they say, oh, I had an accident, well, they were probably a 1.8, a 2.0. That person is going to go to jail, and probably should, because they drank and drove. And those penalties are out there, and I think there's going to come a time when they even get more severe. And I've been saying this for years and years. We should, the people that drive with high levels of intoxication, like 0.18, 0.20, 0.22, and get into accidents, they should have more penalties. The penalties should be more severe for those. But the ones that are in 08 or in 09, what we've done is we brought in a whole group of people who are not impaired. And in our attempts to make the roads safer, we're taking people and we're convicting them of DUI when they only have an 08 or an 09 and maybe even a 10. You start getting to a 11, many people are not that impaired. They can still drive fine. They're not weaving, and they're not generally doing anything wrong. They're not getting into accidents. You don't start seeing real levels of impairment, in my opinion, from what I've seen in the last 25 years, until somebody starts getting to about a 1.4, 1.5. And therefore, that limit that we had imposed many years ago, the 0.15, I still think is the good, is where it ought to be, so that people that are 08 and 09 do not find themselves branded DUIs, drunk drivers, and all that. They're not drunk. 08 is not drunk. 09, you're not drunk. You're not slurring your words. You're not drunk. Now, 1.5, you're drunk. And at 1.5, you're going to jail. So that's what we're talking about as far as this, DUI in the modern world, in the modern courtroom. What we're talking about here today is field sobriety tests, which are the most inaccurate way of determining what someone's driving ability is. The fact that somebody is driving their car, it speaks for itself. Police officer will pull them over, and you'll say, well, how long did you pull in behind them? I followed them for a quarter of a mile. Was their driving fine? Yes. Any other unusual driving? No. You pulled them over because of a tail light, or maybe they were speeding. Maybe they're doing 52 and a 45. And yet when you pull them over, they can't pass the field sobriety test. Now, doesn't driving ability count for anything? It doesn't in the modern courtroom today, at least not unless a good lawyer brings that out and you've got a judge that's going to be inclined to listen to that. It's not whether or not you can pass a field sobriety test. It's whether or not you can drive. It's driving ability being impaired. So it's one of those things, and like I said, as we go forward, and those of you out there that know something about this, you can give me a call, 454-1650. This is George Yates here. Our show is Justice for All, and we're talking about DUIs. Something else which is interesting, too, it's kind of the new thing, and this is the driving under the influence of drugs. And this would be marijuana and other kinds of prescription-type drugs that people take, but specifically marijuana. We're kind of in a new uncharted area there with marijuana, because in Washington State and some of these other areas where they've made marijuana legal, and they have to deal with the possibility, of course, that someone's driving under the influence of marijuana, they've started establishing standards for when someone is impaired because they're driving under the influence of marijuana. In our state, we have not yet established that kind of a standard yet. So, and I just picked up a case the other day where someone was charged with driving under the influence of marijuana, and the standard is unclear. They have to bring in a toxicologist that they have to do the drug report, the blood test, to show that you've got some marijuana in your system, and then the toxicologist will come in and start talking about whether or not that level of marijuana in your system is going to make you impaired, and whether it's going to impair you to the degree that it affects your ability to drive the vehicle safely. And there's no real standard on it. And the toxicologists are saying things like, well, in my opinion, any level is going to impair you. And so that means that, what if you said that about alcohol? Well, any level will impair you. And the fact is, that's what some toxicologists will say. Well, even one drink can impair you. And so the question when you're talking about impaired is it enough to impair you so that you are unable to, is any level of impairment enough to convict you of marijuana, DUI, right, if you will. And that's the standard right now, is that just about any level is. And so once again, you get back to what the level of impairment was and what the driving behavior was that led to the person being charged with the driving under the influence, let's say, of marijuana. But when we get talking about these field sobriety tests, I do think it's really important if somebody is over a certain age to decline. And what you always want to appear cooperative. Most people do respect the police. They should. We respect the police here on this show. We have police guests, and it's important we respect the police and what they do and respect the laws and everything else. But when you're pulled over and you are someone that is of advanced age, and by advanced age, I mean anybody over 30 or 35 technically can be of advanced age when it comes to taking field sobriety tests. It's not showing lack of cooperation to say I'm not going to take them. It really isn't. You're just telling the police officer, I'm not going to take those tests. You've got the constitutional right not to do it. I don't believe I can pass them sober. I don't believe I can pass. I mean, I am sober now, if you want to tell the officer that. So I don't think I can pass them. I don't want them being used against me. This is the number one question that people ask a lawyer, at a cocktail party if they do DUI. Gee, should I take that refusal? Should I take that test? And the fact is, if you don't want to take the test, don't take the test, but don't take any test, as opposed to just taking the field sobriety test and then refusing the other test. And so that's the important thing to remember is taking these field sobriety tests is always a mistake. It's always a mistake. A lot of people, there was an interesting anecdote I heard the other day. There was a fella that was pulled over by the police, and he rolled down his window about 2 inches, and he dropped a little bag out the window that had a little sign on it that said, "Here's my driver's license, here's my registration. I don't have anything to say to you. I don't want to talk to you. And I'm not going to get out of the car. And I'm not going to take any tests." And what was the officer to do? If he'd been pulled over, write the fellow a ticket. The smart thing to do for anybody to, once again, assert their constitutional rights. They've got the right to roll down their window a few inches, hand the driver's license out the window and their registration, and don't answer any further questions. If you're going to write him a ticket for speeding, write me a ticket for speeding. No, I'm not going to get out of the car. Why? If you're just being pulled over for speeding, why does an officer have to ask you to get out of the car? They don't. Right. You're merely asserting your constitutional rights to not incriminate yourself. And if you've been pulled over and you haven't been weaving and you haven't done anything that makes the officer believe that you've been driving under the influence, he's not going to have the right to do any further. And you need to exercise those rights. And that's the important thing to remember. Because if that officer gets you out and you start doing those field sobriety tests, trust me, those tests will be used against you. You're not going to be able to pass them. The funniest story I'd ever heard from a lawyer that I used to know, a lawyer that I used to work with, and now a judge, but made a really funny comment one time, and the funniest comment that you will ever hear is the one they'll say, "Oh, well, I'm going to go ahead and just hand him my driver's license and then close the door and pull the keys out of the ignition and start drinking vodka," and which would mean they can't really arrest you, right? So, but I'm not going to be. That's a funny joke. Okay, don't do that at home. Funny joke, because it is true that some of these some of these officers will pull you over, and they will look for almost anything at night. Now you're driving along at 12:30 at night, and these officers will pull you over, and they because what are the chances that someone might be drinking? That's when a lot of people are out. The folks that are coming home from the restaurant, they're coming home from the bar 12:30, 1 o'clock at night. And officers will pull you over for probably some of the most minor things in the hope that maybe you're driving under the influence. And it's kind of sad. I think there was a time years ago where the officer would have said, "Oh, you're only right around the corner up here. Mm-hmm. Okay, well, go ahead and just park your car, sir. I'll drive you home." Right. And that doesn't happen anymore. It's now, "Oh, I got to write it up as a DUI." Why? Well, because that's the law now. And then once it's being prosecuted, that's it. We're supposedly getting this drunk driver off the road. And yet this person might be 50 years old, 55 years old, pillar of his community, never done a thing wrong in his life, and never had a problem with alcohol or anything else, and probably wasn't even that high that night. But he's 08 or 09, will not get a break in court unless that lawyer goes in and tries to figure out a way to win that case. You know, plea agreements are kind of a thing of the past. You know, when I was first started out defending DUI cases, you could easily go in there. If somebody had an 08, 09, 10, 11, maybe even a 12. I was talking with someone earlier. They were saying, "Oh, well, it's just all about getting more fines for the state." But I'm not sure it's that, because we used to work that out. We used to say, "All right, you know, it's a $250 fine or a $350 fine for a DUI. Why don't we do this? Why don't we reduce it to reckless driving and give him a $1,000 fine?" And we used to do that all the time. We're going to raise the fine, but we're going to make it not a DUI. We might even make the person go to ASAP, but we're not going to make it a DUI conviction. Mm-hmm. And those days are well, for the most part, gone. I think you can occasionally get some plea agreements, but now if you want to get out of a DUI case, you have to go in and win the case on the merits. Those kinds of plea agreements are more and more difficult to get. Deferred findings, you know, that's the old, you know, everybody's heard of deferred findings, right? A deferred finding is when they're routine in drug cases. Somebody comes in, they're possessing marijuana, let's say, first offender, or cocaine, which is a first offender, and you've never been charged with any kind of a drug case before. The statute allows you to get it deferred so that you plead guilty to the charge, it gets deferred, and in a year it gets dismissed, so you don't have a criminal record. We don't have those kinds of deferments available in DUI cases. It's not a matter of statute. Sometimes judges will do it. I'll say, you know what? You do know that anybody out there that's driving on a commercial driver's license, if you get a conviction for a DUI, you will lose your commercial driver's license for a year. And that is the kiss of death. So somebody might be having 08, 09, 10, 11, maybe not even doing anything that inappropriate. They get a DUI, they'll be able to keep their driver's license, their regular driver's license, but they're going to lose their CDL. And that might mean that they're going to lose their livelihood for an entire year. So the penalties for DUI have just gotten stronger. The level of training for the police has gotten much more sophisticated. There are many more police officers out there on the street pulling people over for very minor infractions. The level of training for the police officer in coming to court has improved. These cases are being prosecuted by prosecutors who have policies in place through their offices to, you know, no pleas and no plea agreements and that kind of thing, or sometimes plea agreements, but they're very reluctant to reduce that charge from a DUI. And we have judges who will now often refuse to give someone a break, even though maybe back in the old days they were someone who might have gotten a break. The penalties have gotten stronger, and now we're seeing that even on first offenses, occasionally people are going to jail on first offenses, which was always routine that they would get probation on a first. We do know that on second offenses, people go to jail. Third offense DUI is a felony, a mandatory 6 months in jail, and a mandatory driver's license. See you later. Driver's license gone. Adios. So DUI has become a no-nonsense kind of thing, even though the incidence of drunken drivers causing fatal accidents still is prevalent among the people with a higher blood level, with the 0.15, 0.16, 0.18. That's when people are actually getting to their accidents. And those people, once again, my premise here today is that, and I've always said this, that, you know, if you got a 0.15 or higher, then going to jail, being punished for it is appropriate. But the folks that are down there at the lower levels, I've never have agreed that we should have brought in people that are at 08 or 09. I never agreed with reducing it from a 0.10. Apparently there was some studies that have said that people are impaired at that level, but I don't see it. You get a athletic fella like D, my engineer here. Of course, he probably doesn't even drink. You even drink, D?
No.
You don't even drink, do you?
No.
But, you know, like I said, we're living in an area where you're going to find yourself stuck. And you're going to take that chance, and you shouldn't have. You know, there was old Stanley Hudgens used to practice over in Traffic Court A in Virginia Beach years ago, and he used to talk about what a DUI meant to people. And he'd say, we got 43 people on the docket today, and all charged with DUIs. He says, if they're convicted, you're going to pay a $250 fine. You're going to have to go to ASAP. You're going to have to pay them an ASAP fee, not to mention your attorney's fees, your court costs, and everything else. Then he'd say, you can ride right many times in a taxi cab for $550. And he used to say that and encourage people. You know, you should have called a taxi cab. And don't you know it? Don't you know it? You're driving down the road, you look up, and there are the lights, and you go, oh, no, I should have called a taxi cab. Now what? But you didn't, did you? And now what are you going to do? Well, roll down your window about 2 inches and hand the driver's license to the officer, and don't take any further tests. And, you know, maybe you'll have a shot at getting out of it.
Yeah, maybe.
But once again, you'll lose your driver's license for a year on the refusal. You know, that's the one thing you need to remember is that you will lose that refusal. Many people will make that mistake. I don't know if you know this, but you get the DUI and the refusal. The only way you get out of the refusal is to plead guilty to the DUI. So if somebody's got a DUI and a refusal and they try the case, they can be found guilty of the DUI and get the refusal. You can get a restricted driver's license with a DUI. You cannot get a restricted driver's license with a refusal. So when you decide that you're going to refuse everything, refuse the breath test, and you've made a decision that you're going to say, you know what, I want to get out. I don't want to get convicted of a DUI, so I'm going to try to find some other way to get around for a year. You might be able to get out of the refusal based upon the overall case, but that's always and once again, when you've got some questions about this, give me a call, 491-8800, because each case varies on whether or not you may or may not be able to get out of that refusal if you've decided to not engage in any of the field sobriety tests or any other level of, you know, cooperation when you've been unexpectedly stopped or pulled over when maybe it was one of those occasions when you should have called that taxi cab, as Judge Hudgens used to say. So, because you can ride right many times in a taxi cab for $1,000. Your attorney's fees are going to be high. Your fines are going to be high. Your insurance premiums are going to go up. And you start thinking about it, and, you know, and you know, you should be smart enough to never get behind the wheel, even if you've been drinking anything. And the smart person that's drinking out in a bar or drinking at a friend's house, they shouldn't ever get behind the wheel unless they've been counting those drinks and they know exactly how much they've had and they just know that they're not over the limit. Anybody that's over an 08 should never get behind the wheel of a car. The problem is they don't know what they are. Right. They don't know. And you say, well, and that's where people need to do research on it. You know, the only time people really get to know these things is after they've been convicted, right? They go to ASAP, and ASAP says, okay, that first beer is going to get you to an 02, and the second beer is going to get you to an 04, and the third drink's going to get you to an 06, fourth drink's going to get you to an 08, and it's going to take you an hour for each of those drinks to come out. So when you have that fifth drink, I love how people get pulled over. They say, I've had 2 drinks. They blow a .10. Well, no way. Unless it was one of those big, giant, 40. I had 2 of them. Or the bartender was a really good friend of theirs and gave them a really big. I had 2 drinks, but the bartender was just pouring the vodka all the way to the top of the glass. So once again, this advice that I'm giving about DUI is all made with a very serious caveat. Don't drink and drive. But if you've made that mistake and you've gotten behind the wheel of the car, then, maybe you can take some of this advice as to what you should do next. Because these days the police are, it's kind of like, I get a kick out of I'm a criminal defense lawyer. People will come in and they've been charged with shoplifting. Now, what in the world? People aren't supposed to steal? What in the world? You're going into Walmart or Target and you're stealing. But don't you know that there's cameras? There are cameras watching you no matter where you go in this world today. And so anybody that would go to a store and steal something has to know that they're going to be on camera. Right. Same with the DUI. You get in your car and you drive somewhere at night in one of these high areas, where there's bars and going around. These cops are sitting in the parking lot, and that is their job, to get drunk drivers off the road. And once again, as I've said, a drunk driver is 0.15. But an impaired driver, according to the law, is 08, and you will get convicted. So if you've had 3 or more drinks in the course of any period of time, you're at risk for being at 08 or higher, depending on your blood alcohol, the way your body metabolizes it and everything else. So, if you have any doubt whatsoever, don't get behind the wheel of a car. Get someone else to drive. I've got a lot of clients that'll come in and go, well, everybody else was a lot drunker than me. I was the most sober one. I was the designated driver because I wasn't as drunk as the rest of them. So you get pulled over and there's 3 or 4 people in the car and they're all really drunk. And then, of course, the officer says, well, can anybody else drive this car home? No. The car gets impounded. And everybody, of course, they haven't broken the law because they're not driving. So they have to call and get rides while you, the driver, are being hauled off to jail. So anyway, it's a problem that's been addressed by the law and by the courts, and it's a pretty zero tolerance thing out there with this drinking and driving thing. So be aware. If you got any questions about it, give me a call, 757-491-8800 at my office. And, we're DUI specialists and we sue drunk drivers and all that kind of stuff. So, and the law is changing all the time. And I'm a member of this National College of DUI lawyers, and I know I had the president on earlier this year, and I had another expert DUI lawyer here. And as the show goes on towards the course of the year, I'll get into some other DUI-related stuff, as well as some other criminal defense stuff. And, because DUI really is not the most fun charges to defend, and we don't say fun, but the thing about DUI defense, which is the most interesting about it, is the average DUI client has never been charged with anything else. I mean, he or she has no criminal record, and they're coming in, they're 24, they're 28, they're 32. They have never, ever, there's no juvenile record, there's no adult record, they've never been in trouble for anything, and all of a sudden, oh no, this DUI. And the worst part is, if it's a guy, he's coming in and his wife is upset, and he's got children, he's got this job, and he's worried about this and that, and a restricted license, he might have a CDL. Sometimes you've got a security clearance, you're in the military. I'm telling you, the military's taking a real serious line on these DUIs anymore, and they're kicking guys out for a first offense. If they're really necessary personnel, they'll keep you, but they'll find, if they're whatever reason kind of wanting to let a guy go, they'll use the DUI as an excuse and let him go. That never happened 20 years ago when the Navy has completely changed in its approach towards DUI and towards alcohol related offenses. We've sort of entered a new era of we haven't entered a new era of prohibition, but we've certainly entered a new era where the abuse of alcohol is no longer going to be tolerated like it was back in a generation ago. Those of you that watch Mad Men, the three martini lunch is no longer approved of. So in any event, thank you for joining us today. I really enjoyed our first guest, Joanne, our guest today, Joanne Mertens, who was here. If you didn't get a chance to listen to that part of the show, that'll be on our website, my law firm's website, ghylaw.com. And the book was, about her experiences as a prison matron and supervisor, and the book is going to be available on Amazon. If you want to listen to that show, you can listen in. And this last show on DUI, we'll have that uploaded to our website, and you can listen to it later on if you didn't catch the entire show. So we'll be back on next Saturday from 2 to 4. I'm George Yates. And this is Justice for All. Have a great afternoon and have a great week, and we'll listen. We'll hope you listen to us next Saturday. Goodbye.
CBS News, I'm Jim Taylor.